with the opinion that's been disclosed. Ms. Nolan did not agree that the science says you should not opine on this or that you cannot opine on this. All she says is the science does say you can't conclusively establish it. There are factors, she lays out a lot of those factors that you can look at, decide to indicate how it ended up there. She's very forthright. She says, look, it's possible that this was secondary transfer, but based on the fact that it's single source and the amount that was transferred, in my opinion, is primary. I think under the Idaho Supreme Court's test for expert testimony, that passes. She's acknowledging the limitations, and she's giving her opinion, which is going to assist the jury in reaching their conclusion, because the jury's not familiar with any of these factors that she's laying out for them. So, and as to this idea that she's not qualified, so Ms. Nolan, as disclosed, has been at the ISP lab for 2 decades. She's a forensic scientist. She specializes in biology and DNA. For the last 10 years, she's been the lab manager and overseeing all of the biology and DNA. That includes instructing, as indicated in her CV, law enforcement and others on the collection of DNA. What we're discussing is a critical component of all of that, which is how does DNA get from one place to another? There's plenty of experience to talk about that, while admitting she can't conclusively say one way or the other. But as laid out in the brief, that's never been the test for expert testimony, that you have to be able to say to a scientific certainty, this is in fact the case. Well, the issue of touch DNA and just the label itself, I don't know that I've ever litigated a case where a party has come in and moved to exclude a phrase used by their own expert in their report. She didn't just use it, she used it specifically in reference to the DNA on the knife sheath, exact same way that our expert would use it. And now you have an attorney before the court. She used to be an expert in this case, but now she's an attorney saying, well, you shouldn't do that. You shouldn't, even though both the experts in this case used that phrase, the court should step in and say, you're not allowed to use this phrase that's commonly used in your field because it might mislead the jury. Whatever risk there is of misleading by the phrase touch DNA is easily dealt with on cross-examination. There's a definition that Ms. Nolan provides for that. I assume, though it's not given, that the defense's expert has a definition for that, and they can explain what they mean by that. I don't think it's outside the bounds or intellectual capacity of a juror to understand sometimes in particular professional fields where phrases used may not mean exactly what they sound like. I think we can expect jurors to understand that and to understand the fuller meaning that's given to it. Part of the problem with the defense's motion at this stage is by asking this court to limit not only our expert but their own expert, they're admitting that there's something there to be cross-examined. So if this court orders there can be no statement or no mention of touch DNA, I think that cuts off a very legitimate line of cross-examination from the state.